surveillance, and this bill, I think, on balance, achieves that.
I call the Honourable Leanne Dalzell.
Mr Speaker, I am pleased that I have the opportunity to follow on from the Honourable John Banks because I think I should respond to his challenge to the Labour opposition as to why they are not supporting the passage of this bill, despite the fact that there have been some negotiated changes that were resolved in discussions with the Minister, who I believe has gone certainly a long way to addressing a number of the concerns that we shared with the ACT Party. However, there is a very strong dividing line between ourselves and the ACT Party on this point, and that is that if this is as good as it gets, then it isn't enough for such a far-reaching bill. And I want to remind this House, yet again, what the introductory comments from the report back from the Select Committee actually stated, because I think these words identify the true problem with the legislation that is about to pass into law. This bill is intended to implement a comprehensive reform of search and surveillance legislation, both as regards the core substantive law enforcement powers and the way search powers are exercised across the statute book. Many of the proposed changes are based on the Law Commission's Search and Surveillance Powers report. Currently, the search and inspection powers to be amended by the bill are spread across 69 different acts, with many inconsistencies in the procedures applying to the exercise of powers. Some of these statutes are up to 50 years old and do not cover technological advancements adequately. The bill codifies existing case law in some areas, while in other areas it clarifies aspects of the law that are unclear. Some of its provisions are entirely new and reflect technological developments or reforms carried out in other jurisdictions. Mr Speaker, a worthy aim, but it has not been met. And the reason it hasn't been met is because of the absence of the Serious Fraud Office from its ambit. And I want to traverse the history of why the Serious Fraud Office has not found its way into this legislation. And we have to go back to a former government, back to the period that there was a Labour government, and a decision taken by that government to fold the Serious Fraud Office or into a part of the police to be known as the Organised Crime and Serious Fraud Unit. So that decision was taken by a Labour government prior to the reference to the Law Commission, who was asked to look at those 69 different statutes and to try and bring about some semblance of consistency and principle to the issue of search and surveillance across all of the agencies. So instead of having individual search and surveillance provisions across the individual departments that have search and surveillance provisions, we're talking about fisheries, we're talking about immigration, we're talking about all sorts of different departments of state. We've actually, the idea was to give the Law Commission that task, that important task, of not only looking at the current framework, but actually looking at how that might be made sense of in an integrated, comprehensive way. But because the government had already decided that the Serious Fraud Office functions would be collapsed back within the police and a special unit set up within the police to take on organised crime and serious fraud, the Law Commission itself did not include the Serious Fraud Office within the ambit of its consideration with that Law Commission report. And that meant that the report of the Law Commission was not adequate to address a situation where we had a change of government and a government that was changed on the policy of not standing by that earlier decision, but in fact to retain the Serious Fraud Office as a separate agency. And it was at that point that the problem arose, because if the government of the day had not changed after the 2008 election, then we would have had a bill that implemented a comprehensive reform of search and surveillance legislation, as the Select Committee has reported this bill back to represent. But it doesn't represent that now because, of course, the government coming into office did not proceed with the bill that we had in front of the House. They, in fact, introduced their own, this bill that we see before us today. And, of course, the absence of the Serious Fraud Office means that it is not the comprehensive piece of legislation or piece of reform that we would have hoped to have seen. Mr. Speaker, I think it is very important that the Serious Fraud Office is included within this legislation. And I do want to mention just briefly the provision of the legislation that requires it to be reviewed within a period of 5 years, because I'm a little bit concerned about that, and I'm actually going to be quite optimistic actually about what it could mean. But the particular provision that I'm referring to, since I took my place marker out of the bill, I can't find it. It's 316 of the Act, and what it says is that the Minister of Justice must, not later than the 30th of June 2016, refer to the Law Commission and the Ministry of Justice for consideration the following matters: the operation of the provisions of this Act since the date of the commencement of this section, whether those provisions should be retained or repealed, if they should be retained, whether any amendments to this Act are necessary or desirable. The Law Commission and the Ministry must report jointly on those matters to the Minister of Justice within 1 year of the date on which the reference occurs. The Minister of Justice must present a copy of the report provided under this section to the House of Representatives as soon as practicable after receiving it. Now, I'm actually very keen about these kinds of review clauses. I actually think they are important in major law reform bills because they do put a requirement, essentially, on a minister to undertake a course of action to ensure that our legislation remains up to date. So the review provision of this Act is welcomed, and we may, in fact, we probably will be in a position to be making that reference ourselves, and Charles Javel, as the future Minister of Justice, I'm sure will be responsible for that. But I'm thinking that it doesn't actually preclude the question that we have remaining being looked at ahead of the review required under the Act. And that's because looking at the operation of the provisions of this Act will not identify in itself the effect of the absence of the Serious Fraud Office. And so I think that it would be very useful, even as this bill passes into law, if the Minister of Justice would indeed take the opportunity in the next wee while to start a review of the fact that the Serious Fraud Office is outside. Because I think during the debate, during the committee stages, I got the sense from both the Minister's contribution and also the contributions from some of the members in the House, I got the sense that they felt that the Serious Fraud Office issue was just an issue because of the recent action with respect to them seeking material off the National Business Review. But I want to remind this House that we were informed by the Law Commission when we were in government that in fact it was a regular occurrence and somewhat alarming, indeed, the extent of the Serious Fraud Office's use of its powers. And so I believe that it is important that the Minister takes on board those concerns and has a further conversation with her colleague, the Minister, Anne Tolley, who's now the Minister of Police, about whether this is something that ought to be addressed. And I just make this point that we advised the government about this in November 2010, that when we were in government, the Law Commission advised the then Cabinet that the Serious Fraud Office was in the habit of routinely using their powers to use production and examination orders. These orders do erode the right to silence and should be used sparingly. And as we said over and over again during the committee stages, they were actually designed for organised crime, for serious fraud, the white-collar crime that we see in finance company failures, to enable the Serious Fraud Office to get the accountants who would otherwise be tied up with confidentiality to explain and produce documents in a way that would assist them in their cause. So it is unfortunate that we can't support the passage of this bill, but I hope the Minister has heard our concerns.
I call the Honourable Member David Clendon.
Tēnā koe, Mr Speaker.
Tēnā koe.
Mr Speaker, we think it's a sad day that this bill is passed.